Hi guys, it's Kathy. I hope you're doing well. I guess on holiday weeks we're gonna start a little late because there's nothing we can do about it. Having issue there's a button right here. It says having issues. Click here. No, I'm not. I'm not muted. Can no one hear me? We'll put him if you have to put him back. No one can hear me? Okay. Thank you, Lori. Oh, Lori, I'm glad you're here. I got a clip for you. If you put him back when you're done with him, you'll know where he is, security. I keep telling you guys that. Okay, I lost a clip, so I don't have as much as I wanted to have, but that's all right. Judge Fleischer will fill in the gap today. It's this clip I've been trying to show you guys for like 3 days now. It's not amazing, but I keep losing it. I keep finding it and then putting it somewhere and then losing it. So I'll get it to you tomorrow, sure. It just stinks because now I only have 3 clips for you. All right. I have one for Lori, guys. It's 3 minutes long. Do I make her wait until the 3rd clip or do I do it the 1st clip? You're right. 1st clip. Lori, you're up. I'm going to switch what I have here. I'm going to switch it out. I'm going to do Lori first.
Next, we have Sean Thomas.
Good afternoon.
Good afternoon, Mr. Thomas.
Yes, sir.
Mr. Thomas, you have a warrant for your arrest when you failed to appear for your arraignment. You were summoned in to appear on this theft charge back in October. Obviously, got picked up on the warrant, but we're starting from scratch. So let me back it up a little bit. Do you understand your rights in court?
Correct.
And did you receive a copy of the complaint?
Correct.
You've been charged, as I mentioned, with theft. It's a misdemeanor of the 1st degree, carrying up to 180 days jail and a $1,000 fine. Understand?
Yes.
You have a right to have me read your complaint out loud in its entirety, but it's not required. Is there any? Do you want me to read it?
No, but can I say something about it?
As long as you don't confess.
Yeah, no. I went to Walmart and talked to the guy there that was in charge, and they said they never received an entry or anything like that from the court, that they weren't even going to show up. So that's why I didn't show up.
Okay. Well, listen. You know, the alleged victim can't tell you not to worry about it or anything. You got to show up. What is your address?
582 Jackson Town Road, Lot 4.
Lot 4?
Yeah.
Okay. And you got arrested at home?
Yeah, they came. I just had open heart surgery. I just had stents put in my heart, and I got home from the hospital, and they showed up.
Were they called for service, or do you think they were just checking to see if you were home so they could execute the warrant?
Well, I didn't know why they were there for, because Walmart told me not to worry about it, so that's why I didn't show up. And I wasn't worried about it, so I didn't know why they were there.
Where did you have your surgery?
Up there at Lincoln Memorial.
Okay. Well, Mr. Thomas, I'm going to release you today.
You guys are savage today.
On your own recognizance. Obviously, that won't be the case if you fail to appear in the future, but your case will now be randomly assigned to one of the judges of this court. You'll be notified through the mail of of who that is and when your next court date will be, which will be your trial. You have the right to hire an attorney if you wish. You can ask the court to give you one for free, which we'll do if you qualify. And the application is available there at the jail. But since you're being released, the jail will not send that in for you. That's going to be your responsibility. The main thing is don't wait until the day of your trial to deal with getting an attorney. Do you understand?
Gotcha.
All right. You have any other questions today, sir?
Yeah, so a self-appointed attorney I could get. I know I would qualify because I'm on SSI.
Okay, just get the application, but like I said, you'll have to turn it in, not the jail.
Okay, now does Walmart have to show up on this? Or what? Does Walmart have to show up at court?
If the state intends to prove the charge beyond a reasonable doubt, I think they're going to need a witness from Walmart that claims to have seen you do what they claim you did. So Yeah.
Yeah, so, okay, I'll have an attorney then.
All right.
Okay.
You may go with the officer. Thank you, Mr. Thomas.
All right. Thank you, sir.
Oh, Walmart's showing up, dude. Don't worry. He actually came on. Remember the lady that we had on, I don't know, 3 days ago? Who was so cute, the older lady. He came on right after her, and I've been saving it. I have to spread everything out because courts haven't been in session in 4 days. So I have to take everything that I have and ration out little pieces of it to last 4 days for you guys. That's why when one clip goes missing, it's a big deal. Okay. I hope you're here. I don't remember who it is. One of you specifically asked me to get Judge Kepkow from Weld County in Colorado. Judge Kepkow. I always lose my clips. Did I really say it? Look, it's just I say it fine. I speak the word fine. I lost my clip. I can't find it. It's not my fault. You're not cow. Cap cow. Oh, I guess they're not here. Hopefully they're on replay crew because I mean nothing really crazy happened in his courtroom, but he has some good advice. Well, one little piece of good advice here, so that's enough for me. Let's go to Colorado.
For a dispositional hearing, do we have one?
Yes, can I approach?
Yes. And thank you. Does Brittany?
I do like this judge. He is very sharp sometimes. Like when someone gives him a load of BS, he like fires right back sometimes. He does it a little bit here, so you get a taste of what he normally does, but not too much. Don't worry.
Aston or her representative join us today? Was there victim rights compliance, Mr. Dason?
Yes, Judge.
Thank you. For the record, it's 8:30. The victim is not joining us either, or at least not speaking up by WebEx or in person. She was not required to be here today, or she's not required to speak up today. Is there victim rights compliance for conferral of this plea bargain?
Yes, Judge.
Okay, thank you. So Ms. Carbajal, your lawyer just handed me some paperwork indicating that you're going to accept a plea bargain in this case. Is that true?
Yes, Your Honor.
And I'm sure she did a great job going over this paperwork with you.
She did.
I also want to go over it with you. If at any point you have any questions or comments or concerns, can you please let me know?
Yes, Your Honor.
Give me 1 second, please. So it's my understanding that you're going to plead guilty. I assume, let's see.
Oh my gosh, did it fall off?
The agreement doesn't say this, but I assume it's at account number 3.
It is, yes.
And will I be? Okay, I'll just add that. Attempted robbery, a class 5 felony. This will be a permanent conviction on your record, and this will run concurrently to Weld County case numbers 24M437, 24M131, 23M2103, and Adams County 24CR1443. The people are not seeking any additional jail at the time of the initial sentencing. The parties are stipulating that you pay restitution for Silvermine subs where the robbery occurred in the amount of $93. Do the parties anticipate proceeding to immediate sentencing?
That's our request.
Yes, Judge. Is a defendant statutorily eligible for probation? This is a qualifying crime for the 2 felony rule.
Yes, she is statutorily eligible. She does, the only felony prior is a class 4 drug felony.
Is that the Adams County?
Yes,
And what's the status with that case?
she's on 12 months of probation since June.
And what about the Weld County cases?
Those are both misdemeanors. She's been on probation since July of this year.
Both, all 3?
Yes,
Okay. So she's on probation in Weld County County Court.
Here's how I know he cannot be a vegan. Micah cannot be a vegan. He can tell me right now he's a vegan until he's blue in the face, and I know that he's not a vegan. Because had he been a real vegan, he would have told us a long, long, long time ago, like day one.
In those 3 cases and on probation for the felony in Adams County?
That's correct.
Okay. And is there victim rights compliance to proceed to immediate sentencing?
We're in best efforts, so yes.
Thank you. And Ms. Carbajal, let me ask another question. I'm sorry. Are there any statutory sentencing enhancing circumstances or aggravating circumstances?
There are not, although she is on felony probation right now. The date of offense is a year prior to the date of offense for the class 4 drug felony.
Okay. So Ms. Carbajal, I want to make sure you understand that while I'm going to go along with this agreement, if you were to violate the terms and conditions of your probation, you can be subject to the penalties that are stated in the paperwork. Did you have an opportunity to read and understand those penalties?
No, Michael has so many kids, he numbered them.
I did, Your Honor.
Do you have any questions about those penalties?
No.
Did you also have an opportunity to read and understand this written waiver and guilty plea, which explains all of the rights you have and some of the rights you are giving up?
I did, Your Honor.
Any questions about these rights?
No,
Did you also go over these rights with your lawyer?
I did.
And are you fully satisfied with the assistance of your lawyer?
I am.
Did you also have an opportunity to read and fully understand and discuss
Bonjour.
with your lawyer the legal definition of the crime you're pleading guilty to?
Yes, Your Honor.
When you read it, you noticed that it was broken down into different parts, that definition, and we call those parts elements to a crime. And if this charge proceeded to trial, it would be the prosecutor's burden to prove to a jury of 12 unanimously, beyond a reasonable doubt, each of those elements before you can be convicted of this crime. Do you understand?
I do.
Any questions about that?
No, Your Honor.
This morning, are you under the influence of alcohol or drugs or any other medications or substances, legal or illegal, that affect your ability to think clearly?
No, Your Honor.
Has anybody put any pressure on you to do this?
No.
Are you pleading guilty because you want to get out of jail today, or are you pleading guilty because you're guilty?
Pleaded guilty because I'm guilty, Your Honor.
Do you have any other questions I can answer for you?
No, Your Honor.
And how do you wish to plead to added count number 3, attempted robbery, a class 5 felony?
Guilty.
And Ms. Trujillo, do you believe there's a factual basis to support your client's guilty plea?
Yes.
And you believe her guilty plea is being entered knowingly, intelligently, and voluntarily?
Yes.
One more question for the prosecutor. Is the $93 the final amount of restitution?
Yes.
And you'll be filing today a stipulated notice?
Yes.
And I'll accept your guilty plea. I find that it's being entered knowingly, intelligently, and voluntarily, and supported by a factual basis. The court will enter judgment on added count number 3, dismiss counts 1 and 2. Mr. Decent, anything else you would like to say?
No, Judge.
Ms. Trujillo, anything you would like to say?
Your Honor, we just ask that the court accept this agreement with no additional jail. Ms. Carbajal, while she's been in custody, has focused solely on getting into some type of inpatient treatment. She was accepted into True North SMAT program. We were able to confirm that last week and send that over to Mr. McHugh, which I think is kind of the basis of this no additional jail here. She is on the wait list for the inpatient program as soon as they have a bed open. She's
No, it's just his drones. His drones are out there.
going to plan on being there. She's got great support from her ex-husband as well as other family in the area. So I don't think we'll be seeing her back here.
So inpatient, is that for substance abuse?
Yes.
Okay, thank you. Ms. Carbajal, you don't have to say anything. Anything you would like to say?
No, I'm just ready to get this over and I'm ready to live a life, stop hurting those around me that I love and just anybody around me in general. That's society anyway.
When you put poison in your brain, this
Yeah.
is the outcome.
Yeah, it
When you
is.
stop that, your life gets so much better.
And it will. It will.
And there we go. That's why I got this one clip for the person, whoever it was, that asked me to get this judge from Weld County. Everybody needs to think about what he just said. Got it?
Will get better and I'm glad and thankful to have a program to go to. I think that was the underlying issue is that
Get some tissues ready, guys.
I kept falling through the cracks and
Not guys, girls, ladies, get some tissues ready. Guys, don't. Knock it off.
just not having nowhere to go or no treatment. And I do need treatment. I know I have a problem and it's more than just drugs. So
What do you think it is?
I think it's just a lot of pain from before that I've gone through. So I need to deal with that. and I need to own up to the things that I've done, even though it has been hurtful to a lot of people, my family and friends, and I don't want to hurt anybody, and I need to deal with that grief and that pain in the right way. And I'm very thankful to have somewhere to go.
How old are you now?
I'm 31.
You have so many more years ahead of you.
Yeah, I do.
Okay, I appreciate your honesty and your openness. So the court finds that the agreement is fair and
That's as low as I can go. So Colorado, United States, Colorado, Weld County. I don't know exactly where in Weld County. It's Capcal, not Capcal. Sorry guys. It's Judge Capcal in Weld County. Hopefully that helps.
reasonable under the circumstances, the court's going to place you on 2 years of supervised probation. Conditions of probation are going to include that you comply with all statutorily required terms, that you pay the statutory fees and court costs, that you pay the final amount of restitution for the benefit of Silvermine subs in the amount of $93. I'm going to order that you complete a substance abuse evaluation, follow the recommended treatment. I'm going to order that you not possess or consume any alcoholic beverages or controlled substances not prescribed by a medical doctor, that you be again monitored for your sobriety, that you complete any aftercare. If probation believes that you need other types of treatment above and beyond substance abuse treatment, like dealing with your former trauma or mental health, I'm ordering that they have the authority and discretion to impose those conditions. I'm not going to impose any additional jail because you've been in custody now since August 9th of 2024, and it's now time to start focusing in on your rehabilitation rather than your punishment. I hope that you don't put yourself in a position of getting back into that lifestyle, because then we'll be talking about punishment as opposed to rehabilitation. So that's really up to you. All right, so it sounds like you're all set. I'm ordering that you report to the probation department within 24 hours of being released in order to schedule the signing of terms and conditions of your probation, okay? Good luck to you.
Is your tree up? Did you finish putting your tree up? Did anybody help you? Okay, next. Yay! Ready for Christmas? Last one. Maybe turn it down a little bit. Maybe just turn it down a pinch before I press play, and then you can turn it back up if you need to. I'm not 100% sure how this sound is going to come out.
Agree to at least follow
Yeah.
the plan for now, that Mr. Brenner will represent you. And if you change your mind down the road, we'll come back in here and we can do this all over again.
I mean, I already got somebody in mind that I'm going to be.
Okay, but from today, let's do this. Let's do this. Has he already signed an affidavit of indigency? Okay, so I'm.
Is my audio still not connected? Thank you, Snoopy.
Let's appoint Mr. Brenner to represent you. If you change your mind down the road, that's fine. I'm going to enter not guilty pleas on your behalf at this time. So all that does is it preserves all of your rights. All of your rights are now are being preserved and protected. That's my goal. Okay. So we're going to set this for a pretrial in about 3 weeks. And then in the meantime, Mr. Brenner is going to get all the discovery from the state of Ohio. Where are you housed at right now, sir?
Lucasville.
Okay. Mr. Brenner is going to come down and see you. Yeah, let's get an affidavit.
else I said.
I'll tell you the reason is the way that they discovered it was for online
Well, you're in luck.
That's the pre. That's what you have to go and 30 days and say.
Yeah, we're gonna have to schedule for a pre-shot. At that point, if you want to hire an attorney, in this case, it was a direct.
All right, Mr. Ogletree, let's do this today. Why don't you, this document here, all it says is you, right, as of today, you don't have the funds to hire an attorney on your own. So I'm just asking you to sign that. And then if you don't want to sign it, that's fine. Let's appoint Mr. Brenner, and then we'll set this about three or 4 weeks out down the road. Let's get discovery. And if we need to, we can have this conversation a second time. If you want to hire your own private counsel, you can always do that and tag team in, okay?
I just got a problem with signing things.
Okay, that's fine. I'm still gonna find that right now, because you're incarcerated, that you don't have the funds to hire counsel. I'm gonna make a finding.
Maybe he doesn't know how to spell his middle name like yesterday. Maybe it's something really, really hard like Michael.
That you're indigent. That just means you don't have the funds to hire an attorney today. So I'm gonna appoint Mr. Brenner to represent you. And then I'll see you guys back here in about 3 or 4 weeks, okay? Mr. Ogletree, okay? Sound like a plan, right?
I could show what an attorney again, right?
Yes, sir. At any time. We can always go in a different direction, but for today, let's go in this direction. It's what's best for you, okay?
Why can't I just represent myself in it?
Well, I mean, we're jumping all the way back to square one. I just went through all the problems with you representing yourself, and if that's what you want to do, we'll proceed from there. But you have to sign a jury waiver.
I can't go to bench trial with it.
Sorry, Judge.
I'm sorry. I said jury waiver. I meant waiver of counsel.
I really don't want to sign.
Okay. Well, if you decide you don't want me to represent you down the road, you can make that decision. Right? That's what the judge is saying. But I think what makes sense is, he said, I already heard discovery. Bring it down, I'm married to you. Come to see it, we can talk. If you decide, hey, I don't like this guy, let me move forward. No problem with that.
Okay. Yeah. Now again, everything I've already gone over with you. This is a waiver of counsel. If that's the direction you want to go in, you need to sign that for me, and then I'm going to appoint Mr. Brenner as standby counsel, which means he will not be your attorney of record. He's not here. I mean, he'll be here to assist, but it's going to be very limited. You're going to be representing yourself, which I think is
Okay, Peg Leg, we all know that's right. We all know that. But, I mean, he has the right to, okay? We all know that too. And judges are not allowed to give legal advice. We all know that. Unless they're talking to someone who's trying to go pro se. Then they can cross the line a bit to try to help them get a lawyer. Now, is this judge crossing the line a bit too much? Or is he doing what he's supposed to do as a judge?
a huge mistake.
That doesn't make me right either. That's like a prejudgment from the beginning.
How was it
Yes,
First off, I don't know anything about the case. I'm just telling you that I just did one of these about 6 weeks ago. Similar situation. The gentleman came over from LCI, and on the day of trial, he decided he wanted to fire his attorney and represent himself in front of the jury. And I'm telling you, I'm speaking from experience. I'm not prejudging the case. I just know that when somebody represents themselves in a court of law, they're hurting their chances. it's just, you don't understand the rules, you don't understand the procedures. I mean, just even explaining to you the maximum penalties was very difficult to understand for a layperson, and I get that. And I'm trying to be as patient and I'm not trying to talk down to you. I'm trying to think of words to put it so that Justin over here can understand. But I'm saying, I just had this case, in less than 2 months ago, and he got convicted of everything. I'm just saying, it's hard for someone who does not practice law to come into a courtroom and represent themselves. I think it was Abraham Lincoln, was it that said someone who represents himself has a fool for a client? Was that Abe Lincoln? Pretty smart thing to say. If you represent yourself, you have a fool for a client. That's the old saying. So I'm really bending over backwards, begging you just to let Mr. Brenner start off representing you. That's what I want. That's all I'm asking. If you want to change your mind down the road, fine. If you represent yourself, if I
You calling me a fool? Judge, you calling me a fool? This guy takes one word out of whatever the judge says and twists it completely into something completely different. He keeps doing it. And if I dated this guy, I would go insane. Insane. I would be for domestic violence. I would be in there for domestic violence.
I'm an attorney, and if I represent myself, that's what he's referring to. If I represent myself, I have a fool for a client too. Anyone that does it, that's what I'm saying. I'm not referring to you. I don't know you, sir. I wasn't trying to insult you. I was trying to make a point. Okay?
No, you're right, Judge.
Agreed today, at least, that Mr. Brenner will start off representing you. We'll get discovery. He'll come down and visit you, and then you guys can go from there. Okay? Is that fair?
How do I get my discovery, Mom?
I'm sorry?
Don't I gotta get the discovery anyways?
Do you know how to do that?
Huh?
Do you know how to do that?
No, probably it's a motion of discovery, right?
Well, there's a procedure that you have to go through. And our prosecutor's office actually does it through what's called a matrix system that's all electronic. So that's going to be quite the problem for you. I'm just saying, there's so many obstacles that you have to overcome by making this decision, when it would be just easiest just to say, yeah, let's start off with Mr. Brenner. He'll get discovery. He'll provide you copies of discovery, and we'll go from there. Okay? Then you guys can go over it.
Thank you, Rich.
I won't make you sign the affidavit of indigency if you don't want to sign that. The problem is doing nothing is not helping you either, because I can still make the findings and put down the order, because all of this is being recorded right now. So there's not only Miss Sue here taking down everything that's being said, but everything is being audio and video recorded. And if I have to, on appeal, I can make all of this a part of the record so that the Court of Appeals can see that you and I had this exchange. They can actually see your face and see how you've responded to me. So again, doing nothing is not the right thing either. Refusing to sign those forms is not the right thing to do. If you want to listen to me. If you want to represent yourself, that's fine. If you don't want to sign the waiver of counsel, that's fine. I'm still going to have to make the findings that you're refusing counsel. All I'm saying is, let's try it. I'm sorry. I'm sorry, I can't hear you.
Just go with you feels best, I guess. I really don't even want to say it.
You correct me if I'm wrong. He just said, do what you think is in my best interest.
Okay. Mr. Brenner, I'm appointing Mr. Brenner. I'm going to find that you're indigent for the purposes of retaining counsel today. I'm appointing Mr. Brenner to be your attorney. If there's a problem, let me know, and we'll come back in here. We can do it a different way. We can go in a different direction. This is just preserving all of your rights for today. Okay. So the court's entered a plea of not guilty.
The only other thing, do you want to address bond at a different time? Do you want to address it now? He's in through 2046, 2047. No, I'm sorry, 2043, I believe.
I'm going to set bond at $1,000. I mean, I don't know what difference it makes at this point.
It just acts as a holding.
Yeah. All right. Thank you, Mr. Ogletree. I'll see you in about 3 to 4 weeks. Okay, sir? All right. Thank you.
back out, okay? I will come and see you. I've been to witness school before. Okay? Let's try it.
I loved when he told the judge, and the judge said, you know, you're making a mistake. He's like, you're whatever. What did he say? He said, you're already saying how the case is going to end up. That's not fair. What? No, he didn't. It's not what he said, dude, at all. Okay. That's what I got, guys. Those were the 3 clips. That went quick. That was only 30 minutes. Listen, sometimes they're quickies, sometimes they're not. Let's go to Judge Fleischer. And we're going to go to Judge Fleischer from here to here. And then that's the end. So we are at 2 hours and 33 minutes to 3 hours and 49 minutes. But it's the end of the docket. We stopped it on at here, whenever this was. And I don't know when this was, so don't ask me. Happy December. Love December. Everybody loves December. I don't know. I just feel like it doesn't matter what he did. Attorney or no attorney, nothing's going to be best for everyone with this guy. Nothing. I just said I don't know. Did now you're twisting my... No, just kidding. Yep. This is Wednesday. I'm going with Wednesday. Hi, Terry. Okay, let's find a defendant. Are you ready? Are you ready? Let's get it on.
It's a 12-month deferred, Judge. I told him that if he does everything, you know, we can always approach on an early termination potentially. So.
You know, we usually do that as part of a, in an effort to entice you to complete everything well, do it fast, and be nice to everybody. One of the things we like to do is, you know, take people off early if they do well. You're charged, though, with a very serious case. You're charged with indecent assault, contact with fluid. That's a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you a 12-month deferred. That is a type of probation that if you complete it successfully, you do not end up with a conviction on your record. But you need to understand that you give up so many rights by entering into this agreement, where if you violate the agreement, we can issue a warrant for your arrest. And the full range of punishment is available for us to put you in jail an entire year. As part of the agreement, you will do a TRAS, which is an evaluation to see what conditions you may need. If they think you need conditions and assess it, you
120
must fulfill
volts.
those conditions. As part of the other part of the agreement is that you will have no threatening, harassing, or abusive contact with Ms. Vo. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you cannot undo this or change this. It is there until you complete it or unless it gets terminated through a violation. Is this how you understand it?
Yes.
How do you plead to the offense, guilty or not guilty? I will not find you guilty. I will withhold that for 12 months. If you do everything you're supposed to, we will take you off in half the time. Just don't have any contact with this person. Do what they assess, and then that's it.
Thank you, Judge.
All right. All right, guys. Good luck. Thank you. Okay, Connor, or who's this gentleman?
Mr. Salinas is for a plea, Your Honor. We have the translator also.
Thank you so much. Oseas Salinas.
Salinas.
Mr. Salinas, you're charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine.
Una multa de hasta $4,000.
You have worked out an agreement where they are offering you 45 days in jail
La cárcel.
with credit for the 7 days that you have done.
7 días que ya cumplió.
Is this how you understand the agreement?
Yes, sir.
You need to understand that there is an affirmative finding of family violence. What that means is that if you ever pick up another assault of a family member like this, you will be facing a 3rd-degree felony. You can be looking at 2 to 10 in the penitentiary. And when I mean an assault, it doesn't have to be a drag down, beat down where someone is bleeding. All you have to do is squeeze someone's arm where it hurts a little bit. That
Donde le duele un poco.
can now get you charged with a very serious felony offense. Do you understand?
¿Entiende?
Yes, sir.
You can never own a gun or ammunition as a result of this agreement as well. You are giving up the right to a trial,
Dando su derecho a
right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. You can never change this. Do you understand?
¿Lo entiende?
Yes, sir.
This is what you want to do.
¿Qué quiere hacer?
Yes, sir.
How do you plead to the offense of assault of a family member? Guilty or not guilty?
Culpable o no culpable? Guilty.
I will find you guilty. I will follow the agreement, sentence you to it. Good luck to you, Mr.
Buenas
Salinas. Thank you, Carlos.
Usted con él.
The judge is coming back today.
Thanks. Victoria, I'm gonna grant. All right, come on up. Hi.
Working on a client whose bond forfeited. I wanted to see if you'd be willing to do a walk.
What's the cost number?
It's 2511663.
Is he here? That's fine.
Miss Robbins, come up.
She's not here right now.
Oh, I don't know. I mean, how many times has she taken off on us? At least 2?
This is
Right.
number 2. I understand. I let her know that it's.
Why?
Why what? She take off?
Why would you just keep giving her PR bond after PR bond, right? Tell me, give me a good reason. Why would she take off last time? Give me a good reason. Tell me something, show me the money. But her telling me, I'm sorry, I forgot. I mean, really, over and over. If I do it again, what's gonna happen? She gonna miss again?
Hopefully not, Judge. I was prepared to set the days.
I'm disappointed in all of you because it's here. Give me a reason. Pink song. It's not here though. And I'm waiting for you guys to type it in and no one's typing it in.
So get her in here and we'll talk. I'm not gonna commit to anything until I know what she's doing. All I know is that the case is from, well, it's June, so it's not, let's see.
It's June and the other one is from there. Yeah.
I don't know.
Should I
don't know.
mean, she's just asking if she should bring a bondsman in. Yeah. I understand, Judge. Now, it just is what it is. I'm
I
trying my
know,
best.
Connor. I appreciate the tenacity, of course. Bottom of page 1.
Dismissed. Page 8, daily.
Did Fozzie call her and tell her she's late?
Okay, 2501. Is this, what's his last name? ¿Cómo? Cruz Antonio.
Both these numbers. Should work to the office. Okay, so you can take that back.
Okay. Yeah, okay.
Are you sure that this is the right thing?
We're just pointing to the positive drug test, if you're okay with that.
Oh, that's right. He's not getting on probation. We're just pleading true.
Right, so he's on probation right now, MRP.
Right.
He's got 2 pending felonies. So
Correct.
his MRP is those 2 charges plus.
We're not, no. We'll just go just on the positive drug test. That's it, not the new law violations, right? Yeah, of course. Okay, so is it true or untrue that you have violated your probation?
Sure.
Okay, I'm gonna find that it's true. And I mean, he's got quite a bit of time. He's been in custody for, yeah. What time are we looking at, Melissa? Oh, you put it up here, sorry. So it's 30 days in jail, credit for the 83 days that you've done. I am going to suspend your license now for 180 days. Run it CC as far as the 3,000. This isn't, Alex, this isn't a 0.15, is it?
No, Your Honor.
Did we CC it the last time?
I'm looking at, It wasn't charged last time.
Okay, so just CC it now for the whole amount. So do it's 3,000 and then whatever the court cost is. Mr. Cruz, I want you to understand one thing and hear me loudly, hear me clearly. You have a bunch of stuff that's on your record now. You need to be careful when you're out there in the free world, because anytime you get in contact with a lawyer, when you get in contact with an officer, all they do is they look you up. If you're in a car, they're going to pull you over. They pull you over, they're going to look at your record. They're not going to like it. They will harass you forever and a day. Don't give them a reason to take you down. If you want to get lit, you want to go burn, you want to go drink 35 shots of tequila, just don't get into a car. One button, an Uber, it's now $20 to $50. It's cheap, a lot cheaper than what you're doing now, right?
Is there?
From now on, you're now facing a minimum of 30 days in jail for any new DWIs that you pick up. And I'm going to tell you, even the remote faintest smell of alcohol with your record, they're going to take you down. Do you understand?
Sure.
All right, man. That's a
Hi,
blessing.
Lucy.
Thank you so much.
Hi, Jen.
Judge page 5 and 6, Castillo.
He's here.
It's in arraignments.
Oh, that's, yeah.
Castillo?
Hold on. Wait for the lawyer.
Speak for
See what he's gonna
yourself.
do.
The felon was reset to February.
What?
I have no approach on that, Judge. I'm just telling the chief here. You want me to approach?
Yeah, I mean, I'm ready to set this thing for trial, Mr. Ray. It's 1,700 days old, man.
Well, the felony is not allowing us to.
That hit a little low today. Guys, this does not happen often, and it happened today, and it still hurts a little bit. It's brunch. 2 old ladies come in. One of them orders a Bloody Mary, which is super freaking spicy, by the way. It burns everything when you drink it. So she orders a Bloody Mary. The other one orders a tequila sunrise, which I'm damn good at pouring tequila sunrises. They're beautiful. They taste delicious. I deliver them, and this is one of those ladies, nothing, you can't do anything for them. So, I give her $8 drink, and she takes a sip, and she's like, "Oh, this is way too sweet for me. I can't drink this." It's just orange juice. What do you mean it's too sweet? It's orange juice. Fine. What would you like? A Bloody Mary. I get her Bloody Mary, which takes like 6 minutes to make because you got to put all that crap in it. So she's waiting for her Bloody Mary. Her tequila sunrise came immediately. Her Bloody Mary came 6 minutes later. Not really. Doesn't take 6 minutes. So they're drinking their Bloody Marys, and then their food comes out. Huevos Rancheros is basically you take a tortilla shell, you put an egg on it that you just cooked. And then, we put some sauce on top. That's it. It was a dippy egg. It was an over easy egg right on top of a flour tortilla. I bring that out. The huevos rancheros came out cold. No, it didn't. How can it come out cold? We put an egg on a tortilla and bring it to you. Yeah, tequila sunrise. It's not too sweet. It's orange juice. I'm sorry that you don't like orange juice.
The misdemeanor. It looks to me like the gun was returned 3 days later to a police officer. The chief wants to look into that. So it's not a dead horse yet, but I mean, they're not even offering to reduce it to a misdemeanor. I can't, the DWI offer.
I mean,
kind of-
our cases are they have no reason and no with.
It's just
felony.
my first setting yesterday.
I get it. With us, we've had a ton of settings with him. I know it may be your first, but it's my umpteenth with him.
Oh,
So
I would just like to, at this point, maybe get a cohesive argument for what happened at the gun range, because he's offering a probation on the DWI.
And can I just say, before you even continue, I don't know if you know, if felony told you, but they're offering a dismissal outright of the theft of firearm if he takes a plea down here.
Did someone write that down?
Yes, it's in the notes. I don't know if you know that, but I'm telling you now, it's in the notes.
anytime
If you plead to the
Then
DWI,
I'll try to come here tomorrow. And
no argument needed.
it's in the notes.
Yeah, it's in the notes.
Okay.
We will
Yeah, there
dismiss the
is a
felony.
lot more to that. And that's why you can't have scrambled. Because you need the egg to go into the rice and the beans and not scrambled. That's just scrambled.
Place at DWI. And the
Okay.
possession will go away too.
Wow.
That's
No.
carry for tomorrow, or do you want to? I'm here Thursday in that same court in the 179th.
I mean, you don't even need to go there,
Yeah.
right? Everything happens here. I mean, if you want to roll to tomorrow, you're happy. I'm happy to
Well,
roll
I
to
verbally
tomorrow.
talked to the chief. I guess she didn't look, it's in the felony court notes.
It's in the felony notes.
If it's in the notes, it's in the notes.
Yeah.
You want to
Okay.
go up there and see, I guess?
I've been to that court for 3 days in a row, Judge. They're in trial. It's absolute chaos.
Is it?
I don't mind that. I'll go back.
If you want to roll it to tomorrow, I'm okay with it. Really, George. It's not a big deal for tomorrow. It's until January, ixnay on the reset A, but tomorrow,
Well, I mean, if they got a deal written down, they got a deal written down. I just, do you know who wrote it? Just out of curiosity. Who? It's,
And if, George, and I'll tell you now, if we were to do this and then they don't end up honoring it upstairs, we'll undo this.
Okay.
I'm not down with it.
Okay. Is that?
Year.
Okay.
She put the note yesterday at 12:07.
Because I went and talked to him yesterday and I thought I had the deal, and
I think that's what you guys have been wanting the whole time too, right?
correct, but at one point she said she needed to talk to her chief, and so.
I think it happened. Maybe the trial is.
See what I mean? It's,
That chaos is to your advantage.
I always say the chaos is in my advantage, but
If you're here now. I'm happy to do it now. If you want to wait till tomorrow, we're happy to do that too. You let me know. If you want time to talk, just take it.
How long are you here today?
Hopefully half an hour.
I'll just go back upstairs for a second.
Go, yeah, go.
Oh. She was very friendly.
All right, Judge, page 10. Top of page 10. Counsel has not shown up. I emailed him twice. The defendant showed up.
Why?
Just waiting.
I just rolled to tomorrow, I guess, and we'll tell him that he didn't have to be here.
I'll do it like that. Maybe council should. It's 13 Garza. Here. This defendant.
No, don't say that.
This defendant currently on probation on our case, one of our cases.
Oh, and right, and she picked up a new case, right? Are we doing what? Are we doing a probation?
Probation, correct. But we, 18 months though, because of the
Yeah. Will you remind me the last name again, please?
what?
The last name again?
Studios. Raul.
That's it, Raul.
I left you up to
So,
go get
Mr.
my
Castillo,
beer.
you're charged with a total of 3 cases. You're charged with a felony theft of a firearm, DWI. Shh. And then you're also charged with
Possession, I think.
yeah, possession of a controlled substance with us.
Xanax, I believe.
I want you to understand that this DWI is going to go on your record. It'll be there for the rest of your life. Anytime you get pulled over, officers will see your record, which is not that good. And I'm going to tell you, every time you get pulled over, no matter what you're doing, no matter where you're going, no matter who you're with, they're going to harass
Me
you
too.
because of your record. The record speaks for itself. And they're going to, no matter if you are coming from church and you're dressed to the bells to the nine, it don't matter. They're still going to mess with you. Do you understand? So don't give them the opportunity. If you want to drink, if you want to go smoke, if you want to do this, just don't get into a car. How much money have you spent over the course of the last 10 years on all these cases that you've had when literally $20 clicking one button, maybe 30, can take you wherever you want to go. I'm going out on a date with my wife this Friday. I haven't gone out on a date in months, but I'm going to take an Uber
Same.
because I want to drink like a fish. But I'm going to do it the right way, and that's taking an Uber, right? It's the responsible way. As much as I would prefer to drive, I know that officers hand out DWIs like it's candy on Halloween, so it's easier for me. That's the way you do it. That's the responsible way of acting. You understand? And you got to understand from now on, you ever pick up any more cases, whatever it may be, it's a minimum of 90 days in jail. And on a DWI, it's a minimum of 30 at least. And then with your other priors, they're kicking up to 90 days. No more proverbial slaps on the wrist. You understand? Shh. As part of the agreement, they're going to dismiss the theft of the firearm, the possession of a controlled substance. As part of the agreement, that gun will also be confiscated as well. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, you can never change this or undo this. It will go on your record. It will be there forever. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You can never change this. You understand? How do you plead to the offense of driving while intoxicated? I will find you guilty. I will sentence you to 180 days in jail. However, I will probate that for 18 months. You will do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill those. You must do thinking for a change, which is a class. You must do a DWI education class. This is a first, right? Have you confirmed that it's true first? Alex, please. 2 victim impact panels. No breath test refusal, meaning that if you're pulled over in a car and an officer asks you to submit to a breath test, you must do it. If you don't, you're in violation of this probation. No drugs, alcohol, guardian interlock, and a $100 one-time donation to Mothers Against Drunk Driving. What do you do for a living, Mr. Castillo?
Self-employed as a landscaper.
How much money do you make a month?
Anywhere from 2,000 to 2,500.
Who do you support in this life?
That's myself right now, and I'm actually trying to help my dad. My father, I live with him.
His dad's here.
Say it again.
His dad's here with him and he works with his dad.
Okay, I'm gonna do you somewhat of a favor. I'm gonna roll your court costs, but there is a DPS fine and fee that you're gonna be required to pay. We will give you 2 years to pay it. But you gotta understand, if you don't pay it, there's jail time that comes along with it. I mean, it's gonna end up being maybe like $75 to $100 a month, but you gotta pay it. All right, so I wish you the best of luck. Make this thing work. If you don't, I'm gonna issue a warrant for your arrest and I'm gonna put you in custody. You're looking at an entire 180-day sentence. Do you understand? Do you have a Texas driver license?
I do not.
Okay. We need to make sure that he.
Metal. It's absolutely fine that you're moving slow this morning. That's just okay. It happens to everybody. Don't beat yourself up. And don't let anybody else beat you up, okay?
He gets a license as well. Okay. You need a license, man. If you're a landscaper, freak, you gotta. Don't drive. I'm making it a condition of your bond that you're not to drive until you get your Texas driver license. I want that done within 60 days. Yeah, it's within 60 days, you must get your driver license. I want you today to go there to start doing what you can to get it. I'm not gonna suspend your license here. Do you know what happened on the LR suspension?
I don't think he has a license, so.
Can you
know.
run his license real quick?
I'll see if.
Yeah, it was 4 years ago, the arrest, so.
Yeah, it's not a 2-year, if you amend this plan, because it's with.
Okay. Okay.
Is that the new surcharge?
So George, you give this to your client, will you? This is the driver's license division for DPS. This is who you need to call to figure out how to get your license back. You call them in the morning and say, hey, this is me. I need to get my license. What do I need to do? Because it's been so long, you're gonna have to take the driver's test. You're gonna have to take the written test. When you call them, you call at 7 in the morning. Don't call at 9, don't call at 1, don't call at 2, don't call at 7:02, because you're not gonna get through. Those lines are so busy. You gotta call right when the phone line's open, and that's at 7.
7 o'clock in the
And you'll
morning.
get through.
Yes.
All right.
Sure will.
We wish you the best of luck.
Thank you very much.
Make it work, okay?
Absolutely.
Thank you.
Good job,
Yes.
Mr. Reno.
Thanks.
All right.
Yes, yes, yes.
Have a good one.
Thanks.
Yeah,
Mr. Alexander is here. And I think.
That Mr. Alexander over there?
Yes, back
Come up,
up.
Mr. Alexander. Is that mom?
Yes.
Mom,
Terry, it's perfectly fine. You're not moving very fast this morning. It happens to everybody. Don't beat yourself up and don't let anybody else beat you up for being a little late this morning.
come up.
I would die.
Why are you running, man?
It would kill me.
Nothing good happens
No.
when you run. You know that he picked up a new case.
No, he didn't pick up a new case. The case that you have precedes this case, and all of it is in conjunction with this case. It is
You're
the same.
I believe the case, I don't know if it's filed or not.
Same set of facts?
It is not
Yes.
the same set of facts, but it predates this case.
It involves the same complainants.
Right.
Or the same family, not the
Right.
specific.
Oh, I remember. It's right.
Often
It's the
state is
family and
on
it's.
first, allegedly. So it's not like he violated his
Okay.
bond. I just want to get
Good.
that clear.
So I'm not gonna do anything to your bond. Just, you gotta be careful, man, you know? The thing is that they're gonna issue a warrant at any time. You guys have to be careful. Do you know when have has Michael told
Your
you?
Honor, I've kind of let my client, I saw this come up a month ago or so, and it just has it's still been in the same kind of not signed status. So
We had this exact same situation happen earlier this morning as well. And with that case, they're taking it to the grand jury tomorrow. Hopefully we can get that done with this case so that you guys can get notice of when it's gonna happen, because what you don't want to happen is at some point them issuing a warrant and you guys are in a very bad position when that warrant hits, like you're out of town and they take him in custody when you're in Louisiana or wherever it may be, because then it's just going to be a complete and utter disaster. So the quicker you guys take care of this, the better it is while you're here.
And Your Honor, I'm not, the state doesn't really want to do anything in this case.
Yeah, I get it. I understand.
I just would like a reset and.
I know, but I want him to work out the case upstairs too.
I understand.
At the best, at his best.
I understand.
Michael, can you look at Mr. Alexander? The exact situation about the warrant not being signed, we have another one of those right here now.
Right.
With that case, they're taking it to the grand jury tomorrow. Can that happen with this case? Do you know? So that we can all take care of this at one time? I'm trying to prevent.
Snow's not bad, people. People, snow is not bad. Snow is fine.
Them signing it at a later date when they don't know about it, and then it just exploding.
I can check for him too. If he texts me, I'll check and see.
You're gonna do that on a daily basis? That's like,
I'd have to get the felony prosecutor to agree to get an urgent date. The grand jury would have to agree to give the prosecutor an urgent date to get the case indicted. So I'm not sure at this point. I can send them an email and say that you're requesting that.
I mean, you don't do that.
Okay.
Just,
It is what it is, Your Honor. I don't
Right.
know.
you just gotta be on the lookout. You know, what I would do is probably call a bonding company and let them know, hey, this is my son. Can you just be on the lookout for when it hits and just let us know?
And I'm able to look it up online as well. I mean, it's public information. I see the same.
Yeah,
thing.
I mean,
And are you stuck in your house? Are you frozen solid? Or do you just live your life normally? It snows. They move it. You wear a sweater and you live your life normally.
you have to be on a daily basis looking, I'm glad you came.
I think it is taking a toll on him, Your Honor. So I appreciate the court working with us.
I mean, you've done nothing wrong to this point. There's no need to punish when you've done nothing wrong. The best thing you can do is just stay out of trouble.
That's what they do with our basketball courts in the winter. They fill it with water and let it alone. And then we can skate all we want.
And he's
And-
doing that. He's
And
doing that.
has he gotten a job or doing anything now? Or
He started the GED program.
great.
He started counseling, so he is doing what you asked him to do. He is doing what I've asked him to do.
How do you
there's a
feel?
healthy level of anxiety associated.
It's natural. How do you feel? Are you doing well with the classes?
That's a good
Have you
goal,
been doing it
Lisa.
really? In this life, if you put your heart into it, you can achieve anything. That's what's so great about this place. Really. Just you put your heart, soul into anything can happen. Really. That's what this life is about. Making a lot of money and having a lot of knowledge, Mr. Alexander. And it starts in school, in high school. Okay. We'll let you guys go. Just be on the lookout. Your appearance is waived. You guys don't have to come. Just stay in touch with Mr. Elick and he'll tell you how we go further.
That's why he was required to.
Oh, did we send him for a test?
No, Your Honor, I think he just came, so I don't think.
Yeah, I'd like to send you for a test. I want to make sure you're not using any drugs, okay? Just hang tight for me now. We'll send you for a test and then, we'll set you off now. If something comes back and hopefully it doesn't, if it's clean, then we'll set you off or whatever it is. If it's dirty, well, I guess we'll have to deal with it at that point. I hope he's not using, 'cause we just don't want you to smoke marijuana. That's it. Okay? All right, guys.
So
We're
hold
setting
off on getting.
this right now. No, I want to make sure he's not smoking marijuana. Yeah. Okay.
Is it
Thank
okay
you.
if I hand you something? It's just a business card.
Yeah, you can give it to Steven, sure.
Thank you. Come on.
Thank you, ma'am.
I don't even understand. My cheeks are the only place my feet can feel warm. Both cheeks have me confused. Your feet. Okay, maybe if you, nope. I think you might be. I definitely think you might be a circus performer. You're like, somebody explain. Oh, okay. I have something else, but I haven't checked it yet. I haven't watched it yet. Remember a few weeks ago, a week ago, days ago, it could have been yesterday. I don't freaking know. I showed you that one site that I found. I haven't closed it since. Oh, don't tell me I didn't. I didn't close it. I just have to find it. I have a site that I found. Here it is. No. I have that site that I found as well.
And you show me your Dawson, Caldwell, Massachusetts.
No, you don't want to watch that. That's boring for you. That's not it. Darn it. Hold on, guys. I have something else. I know I do. I just have to find it. If not, I'll just put on another lawyer real quick. I have so many things open. Oh, I can't close that. I'm not allowed. All right, here's what we're going to do. We're going to do one more. Unless you guys have to jet. I'm going to do one more. I'm going to do a lawyer in big trouble, and I've not watched it yet. I don't know how good it is, bad it is. Let's do, I'm going to find one that's like 30 minutes. What do you think? 30 minutes? 40 minutes. I'll do one that's 40 minutes. 47 minutes. Oh, this lawyer was bad. I don't know what she did. Too bad Jay from Michigan is not here.
Commission for Lawyer Discipline. Would counsel please restate your appearances for the record? Thank you. As a preliminary matter, the board is granting the commission's motion.
Okay, I'll do a different one. Sound on this one is bad, so I shall do a different one. Not a problem. I got a different one. No problem. No problem. Let's go back to like 9 years ago. Let's do that. Oh, this one got 11 views. That means, oh no, that's part 3. I'm not going to do that to you. There's 3 parts to that. Oh my. Got a 34-minute one. Let's see if I can find a 40-minute one. There's a 51-minute one. I really want a 40-minute one. All right, how about Charles D. Septowski? Let's do that one. Remember, you might have turned your sound down earlier because of that one clip I told you to turn your sound down. That's the better.
55901 Charles D. Septowski. Mr. Septowski, are you ready to proceed?
Yes, sir.
You may.
Thank you, sir.
Morning. Thank you, members of the board, for hearing my case. My name is Charles Satowski, and what I'm going to do.
Before we get started, I do need to make one announcement. David.
Before we get started, I already hope that he can practice law again. He seems so sweet, doesn't he? Yes, I pre-try clients as soon as they talk. As soon as they talk, I know whether I want them to be guilty or innocent. Darn it, that
We'll
was
call
the
the
wrong
now
button.
the case
That was
case
an
number
accident.
658.
Again, the wrong
Mr.
button.
Satowski, are you ready to proceed?
Yes, sir.
You may.
Thank you, sir. Good morning. Thank you, members of the board, for hearing my case. My name is Charles Satowski, and what I'm going to do.
Before we get started, I do need to make one announcement. David Gonzalez has recused himself from this matter because he was on the evidentiary panel that heard the underlying grievance. So we're proceeding with the full board except Mr. Gonzalez. Go ahead, I'm sorry.
No, that's great. And I would ask your assistance with letting me know when it's 15 minutes so I could reserve some time at the end.
I will do so.
Okay, thank you. Purpose today is my purpose is to attempt to have the disbarment abated or a substitute penalty or a reversion of everything. Now, that's a big, tall order, so I would hope to have the greatest orator possible here to do this. Unfortunately, you got me. So we're going to work as best we can. What I'm going to start with is a short little story. Got a fellow over in Travis County Jail. He's 72 years old, has had a hip replacement, ankle rebuild, 3 cancer surgeries, removal of a kidney. He has nausea from the cancer radiation treatment. And instead of getting a prescription, he got marijuana. Marijuana is medically approved in 34 states, Texas not being one of them. So he's spending 10 days over in jail. Had he had a prescription for a drug called Miram, M-I-R-A-M, it is a synthetic marijuana for nausea. So the form of the transaction that he engaged in, which is substituting the real thing for the synthetic, resulted in his incarceration and breaking of the law. Form over substance. Because the substance is exactly the same. We as lawyers work regularly talking about form over substance. We regularly talk about trying to get to the substance of the matter and seeing what that merits. And that's what this appeal today is about, the substance of the matter. We're also going to talk a little bit about a lack of a full record, and then finally one provision of the judgment of disbarment that is overreaching. Specifically, the allegations that I've created misconduct, and I believe one of the prior disciplinary counsel described it as severe egregiances that warranted penalties. Y'all have looked at my papers and you've looked at the pleadings in this matter, and I, no question about it, committed errors. I had a payment of dues that was late, but I had a receipt and confirmation. Computer follow-up because I had a typo in the.
I think rather than.
Let me continue. If I may.
It sounds to me like, and I don't know, he smuggled marijuana into the jail. I don't know this, but that's what it sounds like. But remember, guys, the attorneys come up here a lot of times and they don't really talk about the real reason they were disbarred. They talk about one case.
Right.
No. And this will be relevant, and I promise it'll be short.
I'll wait. I'll wait.
Okay. And that was transformed into practicing law, administratively suspended because I never got the notice. Subsequently, I did my CLE. It was timely done. It posted 8 minutes late. I tried to get an extension. I went and paid the penalty. I paid it to the wrong box. That resulted in a subsequent administrative suspension. And again, I paid it as soon as I knew about it. Those are both described later in the disbarment proceedings as intentional acts ignoring the pronouncements of administrative suspension. For something to be intentional, you gotta know it. Didn't know it. My third allegation is that I withheld a worthless escrow. And yet I had to sue the person to take it back, and there was an acknowledgement that that wasn't, in fact, a legitimate complaint. And the fourth allegation is the best one. That's the best one of all. Because while I'm on the suspension from this worthless escrow, opposing counsel intentionally pushes the case so that my client has to be represented. I attempt to get substitute counsel. It's all followed up. That's wrong. But in the course of the bankruptcy proceedings, there's final order that cut off activity, except the bar reaches beyond that and says, ignores the final orders and says that's a violation too. Now, if we're talking about a system of egregious errors that warrant discipline, then I don't think that meets the standard. But it goes further. When we talk about this matter, we talk about providing a full and complete record. In the course of the disbarment hearing, all of the witnesses of mitigation, all of the statements and information and exhibits to mitigate were excluded. That doesn't constitute a full record. There was a request for a rehearing and the readmission of those same materials, which was denied. There was a request to expand the record for this proceeding and denied.
Did you, at the end, you had 10 witnesses for mitigation, the ones that you say were excluded. I am remembering that each member of the panel confirmed that they would accept your tender of what those people would say. Am I understanding the record correctly that
no, sir,
they accepted the tender of what your witnesses would say?
No, one member of the board said, well, they'll all say something nice. So, okay, we'll acknowledge that. Mm-hmm. That's not sufficient.
Did you give any bill to present the evidence you thought that would be presented?
I'm sorry, I don't understand your question.
Did you preserve any record of what evidence you thought each of those 10 people would give that would not be cumulative?
Yes, they subsequently provided statements that I tried to admit during the rehearing, which were again excluded.
Mr. Septowski, did you use the name Cameron Chandler to file materials in bankruptcy court on behalf of Robert Farmer Jones and Esther Jane Jones?
No. Cameron Chandler was supposed to be the standing counsel. My assistant did not contact her, and we used her in error. And I apologize for that, but that was not to my knowledge. And as the deposition record reflects for Mr. Allums and the court proceeding in the bankruptcy court, I didn't know.
Did you have permission?
I'm responsible for that.
Did you have permission from Cameron to file?
No, my assistant never contacted her.
It sounds like he's a big fat liar, guys.
No, any of that.
At the time of the filing, you were under administrative suspension, were you not?
I was, and that's why we had substitute counsel, and that's why I had my assistant contact her, and that's why it didn't happen. And I didn't know, but it doesn't matter. And the reason it doesn't matter is because final orders of bankruptcy court closed that issue. If there were any issues with regard to the filings, they had to be raised before that final bankruptcy
Are you
order.
saying that the state bar then or a complainant can't do anything about if it's perceived that filing was as alleged?
That's what res judicata is, sir. And the whole point is that was raised on appeal in the bankruptcy court because of this disbarment. It was summarily dismissed. Now, we all know that final orders preclude further review of anything. We know that starting back to the first grievance.
But the final order issued by the bankruptcy court directed the U.S. trustee, in addition to removing you from practicing in bankruptcy court in that district, instructed the trustee to provide the documents to the State Bar of Texas to consider whatever action was needed to pursue this on a disciplinary thing. So the final opinion specifically carves out and directs this to be looked at from a disciplinary point of view.
Yes, sir, it does. And that judge is wrong. She was wrong because she knows as well as all of us do that a final order precludes further review of the underlying issues. Now, that doesn't mean that, that's her opinion. We respect her opinion. She's a federal judge. Okay? Doesn't mean she's right. Just because a cop has a badge doesn't mean he tells the truth. Just because a judge makes a ruling, it doesn't have to be right. But
whether it's right or not, at some point, doesn't it have some value?
It does. It does. And it should be reviewed. But in this case, the referral to the state bar is but one step that the state bar was pursuing. After the suspension over the worthless securities, there was a request for a competency or a psychological review of myself. I passed it without issue. So therefore, state bar investigators followed to see that I wasn't practicing law, looked into cases that had any case numbers that I had. Mr. Berry showed up in Dallas for this bankruptcy motion and quite possibly prepared it. We know that subsequently to that, there was a preparation of the grievance while this issue of the bankruptcy was being resolved. The point is, in the bankruptcy, we say the client paid all the secured creditors, did everything right. I've had 35 years of taking care of people. Since this disbarment, I'm precluded from practicing law, so I've been taking care of disabled people, taking them to doctor's appointments, helping them with filling out government forms.
Oh, he was
Not
a bad,
representing them
bad
because I'm
boy.
allowed to do that, but helping them understand what the form is that says they can have their Medicare benefits or their VA benefits.
Let me ask you, what about the other allegation where it says, quote, allowing for non-lawyers in his office effectively to continue his legal practice while his law license was suspended? Can you comment on that?
Yes, sir, I can. My law clerk said, we'll get somebody and get back to you. That's it. That's what he did. We didn't have anybody get back to him. The suspension was but weeks from being over with, and so we let it sit. That's the letting somebody else handle my law practice. I have associates in my other practices in St. Louis and Detroit, and I called on some of them to handle things, but they were not Texas attorneys, so they couldn't respond to that.
Do you practice where else?
In St. Louis, Missouri, and in Detroit, Michigan.
And what's the status of your license in those places?
At this point, my status in Michigan is fine. I'm in good standing. In Missouri, I'm inactive because of some medical issues that came up. I had a heart attack.
Missouri?
Actually, I'm in the airport in Nashville.
So no, you're inactive in Missouri,
yeah, yes. Okay. The final thing that I want to bring to your all's attention is this issue of what's fundamentally fair. We've had procedural due process throughout this matter.
He makes me want a grilled cheese sandwich for some reason. I might just go make one.
Substantive due process is where there's actually somebody hearing it with an open mind, like y'all. Your all's job today, as I read the statute and understand it, is effectively a de novo review. You're looking at what's not only has happened, but also what a right outcome is from looking into all the facts, reviewing all the records. That, I believe, has been abused. In some regard, I became a targeted person over bar dues, over the CLE, over this worthless escrow, and then finally being followed around for the breach of suspension. That's not enforcement.
You have 2 minutes, and at least during that 2 minutes, can you tell us what penalties you would ask us to impose if we were going to consider something less than disbarment?
Well,
you think is appropriate?
Yeah. In a perfect world, I'd ask you to wave the flag, send me away, and say, have a nice day. Realistically, I'd ask you to impose a suspension of a year or two. And because in all of the cases that are on the VOTA website that I reviewed, there was criminal activity that constituted a basis for disbarment. There's no criminal activity here. And reasonably I would ask that that be a alternative imposition of a penalty. I believe there's a fundamental issue, though, that needs to be looked at, which is bar counsel said we want serious allegations to allocate our resources to. Argues and CLE and worthless escrows, those are not serious allegations. I shut down a multi-million-dollar money laundering scheme in that worthless escrow. My client retaliated with this escrow grievance. Okay, that's not right. I shouldn't be the one standing here, but I am. Okay, so let's talk about reality. Reality is I've been found guilty of all these things, and the argument presented was that I regularly and routinely ignored the suspensions. The first two I didn't know about, and the third one I tried to not do anything except get a substitute counsel and stay out of the way, and I screwed that up. Okay, am I responsible for that? Of course, because it falls back on me, and a penalty should ensue for that. Okay, none of that, absolutely none of that is serious penalties that harm the clients, the profession, or our legal standing. My disbarment, and this is part of what's so difficult, is I can't look at any mitigating information or any mitigating exhibits to tell you about a 40-year career of accomplishments. Okay, but I can tell you about my credentials. I'm a lawyer, postdoctorate in tax law. I was CPA president here in Austin. I have a PhD in accounting. I've been accounting chair and a business dean, advisor to the White House. Okay.
Mr. Sapkowski, your time is up.
Thank you.
We'll give you a short time for rebuttal after you've written the
May I proceed?
You may.
May it please the board, good morning. So good morning, yes.
I'm sorry, I referred to you as Sam. I meant Ms. Stevens. Thank you.
That's quite all right.
Oh, no, we knew what you meant.
The Board of Disciplinary Appeals should affirm Mr. Sapkowski's judgment of disbarment based upon the egregious misconduct that was demonstrated to the evidentiary panel below. And there are three topics I'd like to address with you all today. The first is that Mr. Sapkowski failed to adequately brief the issues before this board, and I'll be very short on that issue. The second is that even if you delve into the conclusory statements that Mr. Sapkowski does make in his brief, you will find that the issues are not a basis for reversal of this judgment. And lastly, and very, very importantly, the judgment is more than amply supported by the record that is in front of this board. And I'm actually going to switch up the order I was going to take this in. I'm going to go straight to the ample evidence that this board has to look at the record below that supports this judgment of disbarment.
Does a substantial evidence standard require here?
That's
apply
correct. Yes, Mr. Clark. The substantial evidence, it's laid out in the disciplinary procedural rules that substantial evidence is the standard of review here. And I'm going to hit some highlights of the record below. You've discussed with Mr. Sapkowski the bankruptcy opinion. There's also a state court judgment finding that Mr. Sapkowski practiced while suspended. And I'd remind the board that this was a practicing while disciplinarily suspended pursuant to an agreed judgment. There were 3 months of active suspension, May through the end of July of 2013, to which Mr. Sapkowski agreed he would be suspended. And yet he still violated that judgment. So the state court judgment has a finding that he practiced while suspended from the practice of law. Mr. Sapkowski's own admissions on the record below at the evidentiary hearing regarding his claimed out-of-state exemption for the occupation tax, that supports one of the rule violations. He made an admission about his firm name, that supports a rule violation. Then we move into the bankruptcy court's opinion, and I'll point out a few highlights from that. The court found that Mr. Sapkowski's story is, quote, incredible and an after-the-fact fabrication. The court went on to find that Mr. Sapkowski had attempted to mislead the court with respect to his knowledge of material relevant facts. It found that Mr. Sapkowski prepared documents and pleadings that falsely represented Ms. Chandler's representation of the debtors and affiliation with his law firm during the suspension period. and I know you all know this, but I would point out again that Ms. Chandler was living in Alaska at the time, had not practiced law in Texas since I think 2009, had only been semi-affiliated with Mr. Septowski for one case where she represented him in Texas and then withdrew in 2009. She only practiced family law in Alaska. There was no contact from Mr. Septowski or anyone in his firm to get permission to use her name. There's essentially a stealing of her professional identity.
And she was not licensed. She was inactive in Texas.
That's correct.
And was not licensed in federal court.
Correct.
My sister just got pulled over for another DUI and used my name. I hate when people steal other people's names. It really, really makes life hard.
And to further the fraud here, it's not only her name, it's a false state bar number that was used, and it was not her address in Alaska that was used. It was Mr. Septowski.
Wait until you see Bill's stream tonight at 8 if you want to giggle. I'm going to win that shirt tonight, guys. Guys, I'm going to win that shirt tonight.
Septowski's law firm address. So she had no way to know that her name was being used to file bankruptcy documents for clients that she'd never heard of. The bankruptcy court's opinion went on to find that Mr. Septowski either filed directly or authorized Ms. Ports, this woman out of state, to file false documents and pleadings in the debtor's bankruptcy case during his suspension. Not only were these things presented to the evidentiary panel below, Bar Counsel brought in...
No, sorry, Linus. Tonight's Bill's stream tonight is going to be epic. He doesn't even know it yet. Yep, he'll be powerless to not laugh.
Witnesses to testify about these issues. And then in addition to that, provided certified copies of the documents that were filed in the bankruptcy case. There is more than ample evidence provided to the evidentiary panel to support their judgment of disbarment. Now I'll move on to the procedural argument.
Okay, guys, Drunken thinks he won last night. What do we think? Did Bill belly laugh last night? Tell me, let me know. I didn't see last night. I've been so sick, guys. I was just trying to get my stream together, and I worked a double, the day before. So I didn't see it.
Documents that I had intended to start with.
Can I ask you one question? And I don't know if I'm getting way ahead or whatever. What is your view on whether any of the violations by themselves would result in disbarment, or is it necessary that we consider all of them?
Well, I think there's ample evidence to support each rule violation.
No, I'm not asking that. What I'm asking is, assuming each of the violations occurred, would each standing alone warrant disbarment, or do we have to consider the whole?
I think the answer is potentially. As this board knows, Mr. Septowski had 3 prior judgments of suspension against him, 2 of which I believe were fully probated and 1 was active. That is a consideration that the panel takes into account when determining what sanction is appropriate in the current case. And so that, coupled with any of those rule violations, might have resulted in disbarment. I might flip to the rules.
Yo, this man is a scoundrel.
I think that this is speaking off the cuff, but that each of those rule violations by themselves, coupled with the prior suspensions, would have been supported for a judgment of disbarment by this panel. But again, this board does not have to go there. There's ample evidence for each rule violation and support for the judgment of disbarment. I'll briefly address the inadequacy of Mr. Septowski's briefing, and then...
Counsel, why would the commission want to win the case on that technicality?
Well, that's why I was going to briefly address it, Mr. Black, is just to reiterate that this board and the courts are well aware that briefing must be adequate in order for the board to make a proper determination. This board is in a neutral position, and having to sort of pull out from conclusory statements arguments that counsel is supposed to make, go conduct research that might be supportive of those issues, and then scour the record for some supporting information. It takes this board outside of that neutral role and makes you an advocate, and that's simply improper. And so that's why I wanted to address that, but I'm happy to move on to the substantive arguments if you would like.
We would.
I have a question first, sorry.
Yes.
Can you tell us what weight we should put on the fact that Mr. Septowski had witnesses that were going, he said representatives were going to mitigate the circumstances. And I think he said in his oral argument that he had other documentation that was not allowed. Can you expand on that?
I'm happy to. This is the last point, and Mr. Septowski talked about perceived procedural irregularities of the hearing. And for a board or a court to reverse based on the exclusion of the improper exclusion of evidence, you have to have three things. One, you've got to have a preservation of the evidence that was excluded. And we actually don't get to the second 2 points because the first was not met. But the second is that the appellate court looks at that evidence and determines if it's material to an issue at hand. And then if it is, did the exclusion of that evidence probably result in an improper judgment? Like I said, we don't even get to the second 2 points because Mr. Septowski did not properly preserve the error at the evidentiary hearing below. And in fact, when he was told that the panel would not hear from these witnesses, he acquiesced. He didn't even say, I object to this, much less make a showing of what the evidence, or excuse me, the testimony would have been. And that is required by the case law. There must be at least a description of what the evidence would have been.
And why was it excluded?
I'm sorry?
Why was it excluded?
The panel decided not to, they just made a ruling that they would.
Well, actually, he had closed on the evidence.
That's true.
They had then closed the hearing. And then he said, now how about doing mitigation after they announced their decision, is my recollection.
Thank you, Mr. McKenna. That's
But,
correct.
but it is accurate, isn't it, that Jeff Bishop and Melissa Ward Meyer and Wayne Sharrow and others furnished letters afterwards? Did the contents of any of those letters in any fashion relate to mitigation issues that may have changed the outcome?
Well, I think the general characterization of those letters is that Mr. Septowski is a good guy. They don't directly go to any of the factors that the panel considers that are laid out in the procedural rules, such as a consideration of the harm to the client in the case, the harm to the profession, the, well, if I might step over and grab my book, I could go through the factors, but to my way of thinking, they don't directly go to any of those factors. So Mr. Septowski makes 4 sort of general allegations, and I'm going to address those in turn. The first is an alleged conflict of interest by bar counsel, and he points to 3 different authorities to try to support this argument. The first is the Texas Rules of Civil Procedure. The second is Rule 1.06B1 of the disciplinary rules. And then also he mentions the 14th Amendment to the United States Constitution. The civil procedure rules, as we pointed out in the brief.
It's never really good until they point out an amendment, guys. This guy is not okay.
There's really no tie to a specific rule, so it's unclear why Mr. Septowski points to the civil procedure rules when generally when courts are looking at whether to disqualify counsel in litigation, they look at the disciplinary rules for guidance.
Sir, is a chuckle a belly laugh? Is a little chuckle a belly laugh? I gotta know.
And so moving into 1.06B1 of the disciplinary rules, that rule essentially prohibits a lawyer from representing client A if that representation will conflict with the representation of client B, with the lawyer's own interest or the lawyer's law firm's interest. And there's really just not a scenario in the underlying litigation that fits 1.06B1. So that.
Tell you what, guys. If what happens tonight in Bill's stream does not in fact make him laugh, I shall send Drunken a shirt for making him chuckle. Because that's big.
That is not a basis for reversal of this judgment. And then lastly, under this umbrella, Mr. Septowski makes a substantive due process sort of argument. And substantive due process protects citizens from arbitrary and capricious action. And as the board can see from the record below, this evidentiary panel did not act in an arbitrary way. There was substantial support for the decisions made in this case. And so his substantive due process rights have not been violated. Next, Mr. Septowski makes some general constitutional claims. He claims that his 4th, 5th, 9th, and 14th Amendment rights have been violated. The 4th Amendment protects against unreasonable searches and seizures. There was not a search or seizure in this case, and so it's really not applicable. Mr. Septowski mentioned some emails that had been subpoenaed by Bar Counsel. Those emails were not ever used in front of this evidentiary panel, and so he can show no harm based on that. The 5th Amendment protects against our right to not self-incriminate and protects against double jeopardy. There are a couple of problems here with the self-incrimination portion of that. Mr. Septowski never raised this at the court below, at the panel below, excuse me. And as the case law points out, not only do you have to raise it, you have to raise it on a question-by-question basis. And it has to be raised in response to a question that the answer to the question would likely result in a criminal responsibility. And we can look at the record and see that there was no such question asked. And then even if there had been, Mr. Septowski is required to plead the 5th then and there on a question-by-question basis. And that simply didn't happen here. And then moving into the double jeopardy statement, double jeopardy prevents the, second prosecution of a criminal case. And so that's just not relevant in this case. It's well settled that disciplinary cases are civil in nature. It's stated in the disciplinary rules as well as many cases affirming that. His 9th Amendment argument, the 9th Amendment says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Hold my beer. Wait for tonight.
Mr. Septowski pointed to no specific right that he claims was abrogated here. And so we don't really get a full analysis of the 9th Amendment due to it's unclear what the argument is. Lastly, under the constitutional analysis is, again, the 14th Amendment argument. I addressed the substantive due process. I think Mr. Septowski in his argument actually conceded that there was procedural due process. But if I misunderstood that, I'll go ahead and describe it a little more. He has the right to have notice of the hearing and to participate in the hearing in a meaningful way. And in fact, he did have both of those. He was given notice of the hearing well in advance, and he actually attended the hearing, participated, and called witnesses and provided documentary evidence. And so his 14th Amendment rights to substantive and procedural due process were not violated. Lastly, Mr. Septowski has argued that he'd been unfairly targeted by the bar. And I think if this board reads the evidence against him in this case, they'll realize that the persistence of bar counsel in prosecuting this case was absolutely called for. The allegations against him were significant and required obtaining various witnesses to testify and documentary evidence, and bar counsel did her job in establishing that Mr. Septowski violated 5 or 6 disciplinary rules in this case. And Mr. Septowski points out that bar counsel went to a hearing. Well, that's not surprising at all, in that hearing went to the very heart of the issues in this case. That hearing was before the bankruptcy judge, who was considering whether Mr. Septowski had improperly used another attorney's name, whether he had been practicing while suspended, whether he'd been practicing through his paralegals. And so to call that targeting is very misleading. Bar counsel was simply doing her job in this case. I think that has addressed all of Mr. Saptowski's substantive arguments, but I would remind this board again that there is ample evidence in the record below to support this judgment of disbarment.
That's so funny you said that. This is a Mexican lager. Can you read that? It says Mexican lager. It's a loco. It's a cerveza for real.
Mr. Saptowski has pointed to no issue that would require reversal by this board, and the commission respectfully urges this board to affirm the judgment in all respects.
Ms. Stevens, yes, I'll just
They
complete the
will
record. Is it
never find your body.
2.18
ever.
imposition of sanctions where it lists A through J that you were making reference to earlier?
That's correct, yes, sir.
Any other questions? Thank you very much. Saptowski, you have 5 minutes.
Thank you, sir. Ladies and gentlemen, thank you for letting me respond. I'm taken aback a little bit listening to bar counsel because those are hurtful statements. I never had any intent to violate any rule. I screwed up. We created a typo. I got a posting wrong. I have a withholding of an escrow that was not withheld. And then I have substitute counsel that's screwed up, and it has all sorts of related activities. Once it's screwed up, it's screwed up. Of course I'm responsible for all the rest of it, okay? None of it, individually or collectively, constitutes reasons for disbarment, constitutes reasons for slapping me on the wrist, constitutes reasons for taking 40 grand, constitutes reasons for lots of stuff, but doesn't constitute saying that I'm a harm to the profession or my clients. The first canon in the DR says you take care of your clients. I did that. And when forced by compulsion, by opposing counsel going forward in the state court case. And by the way, the state court action was that I didn't respond to emails. Mr. Saptowski, you can't take care of your clients during a suspension because you I may not understand that, have, sir. you may not have clients during a Right. suspension. Did you advise your clients Of that you could course. no longer represent them? Yes. and So I you had advised them no that duty to them. They had the duty to find counsel if they needed counsel, but you weren't doing something to help your clients because you had no clients at that time. Wouldn't that be correct? Did you have clients during your suspension?
Of course, I couldn't have clients during the suspension.
Did your office have clients during your suspension?
No.
That is so sweet.
I
Oh
also
my
don't need
God.
people.
But your
hanging.
argument was that you were helping clients, and I
Yes,
just,
I was helping people that were left in
Citizen, every single Thanksgiving from here on out forever, I'm going to do exactly that for your wife, in memory of your wife.
Never Neverland.
Isn't
The
that-
husband had
isn't
a
it
heart
their
attack.
responsibility?
There was, pardon me,
I
is it
think
my
what Ms. McKetta is
responsibility?
saying, and
Is it my responsibility?
Oh,
Mr. McKetta says no. The canons say yes. And I tried, it says never leave a client in the lurch. Okay? I tried to do the best I could, which was get somebody else. Okay?
The legal point is
I
they
did it
were no
wrong.
longer your clients. Therefore, the
Yes,
canon
legal
did
points
not
are no
apply.
longer my clients, but there are people that are counting on me. And there are people that looking to me to help them and save them. And
if they
I-
were still
I
looking
managed
to
do
you,
that.
you were not making clear to them, were
No,
you?
sir.
That
I
you had
did
no
make it clear
power.
to them.
You had no
And I did
power.
make it clear that we had to bring in a substitute counsel. And I did make it clear that we had to, that their interests had to be preserved.
Did any of them talk with substitute counsel?
No. They didn't. They said, take care of it for us. So I had my assistant take care of it. Turned out he didn't. That's wrong. I should get spanked for that. Okay? I screwed that up. But I was as surprised as anybody when we were in that bankruptcy hearing. And that's on the record. I didn't know. Okay? I'm responsible, but I didn't know. All of this suggests, all the representations here are that I intentionally violated a bunch of administrative orders that if picayune would be a nice way to describe them. Okay?
Here's
But
my
the
problem.
bottom line
Today,
here is
I'm not
I didn't
hearing
do
you take
anything wrong.
accountability. Today, I'm not hearing you admit that you were suspended for 3 months
Yes, sir. I
and that
was-
you were still taking care of clients.
No, sir. I was passing it on to people to see to it that the clients were taken care of. I couldn't leave them in a lurch. Maybe that's what the.
So
board
help me
rules
get an
require.
example of what it is you told to client X about the Alaskan lawyer. What did you say to that client?
I told them, look, we've got a person that was my former assistant. We've looked to them to act as assistant counsel in this matter, and I'm told that they have.
Did you give the phone number to the client, to the former client? So you were still handling the legal affairs of the client during a period of suspension?
No, sir. I was handing it off and saying, look, this is the best I can do for you. Okay? Did I do that right, or did I do that as well as I could have? Probably not. But I've been taking care of people for 35 years, with or without a bar license, with or without a CPA license, with or without any license, because that's the kind of person I am. You do what's right. Now, I didn't intend to
Sir.
violate any of these rules. If I did,
Sir,
I did.
let me
I
stop
get
you right
spanked.
there. Do you understand that as a lawyer, you are solely responsible for supervising people in your office to make sure they don't do anything that violates rules and breaks
Yes,
the
ma'am.
law or any of that?
Yes, ma'am.
So
And I'm responsible for that.
can
No
we
issue.
agree that I didn't know, doesn't matter under these rules? You are responsible for supervision of
It
your
does
system.
matter as to whether or not I intentionally did it. Am I responsible for the outcome? Yes. Am I responsible for knowingly and willingly violating the suspension? No. Because I didn't intend to. There's other lawyers that I could have brought in and
I right now just super pissed off that no one else did.
emails that said, look, I can't talk to you right now. Can't do anything.
What action did you take against the assistant that supposedly, without your knowledge, used a false name and a false bar number and all that? What action did you take against
I've had him
that?
for 20 years. He's got cancer, and no, I didn't do anything to
You
him.
just said,
Jen, this is why we love you. I already guiltied him in my head 100 times, and there you are. There you are, swinging for him.
oh, well, I didn't know.
No, I said, you put me in a bad place. Okay. And that's the way it is. He understood he made a mistake.
I'm sorry, he didn't make a mistake. He blatantly lied
He
to
didn't
a
do what he
court.
was requested to do.
He blatantly lied to a court. Can we agree on that?
I'm sorry. No.
He blatantly lied to a court.
No, ma'am, he didn't lie to the court. He told the truth. He said, look, I didn't do it.
He filed a pleading from your.
No, ma'am.
Okay, I'm not gonna argue with you.
He didn't file any
Mr.
pleadings.
Step, hold
He
on,
didn't know how.
hold on. Mr. Stepkowski, your time is up.
Let
we-
me
hold on.
make one conclusion.
No, hold on. Your time is up. Does anybody else have any questions?
No.
Thank you very much. We appreciate the argument. We will take it under advisement and advise you of our decision. Thank you. We are adjourned.
Oh boy. Oh boy, oh boy. That was awesome. I know that sounds boring, but I thought that was freaking awesome. That guy. He's just a liar, guys. He just said so many lies. I mean, he would put a drop of truth in something and then lie. Oh, I wish Jay from Michigan was here. He would have loved that. All right, guys, we did it. We made it to the end. Late as usual. In 2 hours, judge comes on. Yes, let's go. I think I'm just going to stay awake. That way I just don't miss it. Uh, guys, get some rest. It's Monday. I will see you really, really, really soon. Do not forget to go to Bill's stream tonight, American Courts, 8 o'clock Eastern Standard Time. Do not forget. I'm serious. You're gonna be sad if you miss this one. This one's gonna be great. Oh yeah. Also, Judge Fleischer's court is gonna be insane today. Just gonna be insane. Please do not talk about anything bad in his chat. Help us keep his chat up so it doesn't get taken down. Please. We're gonna be having enough problems with everybody else. Don't you guys say drugs, alcohol, anything. just don't go into Discord. I am begging you. Bye, guys. Thank you so much. See ya. Fibers.
Got these life that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Freedom tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each string she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no